seated, please. Silva versus General Labor Staffing Services, and we noticed this is set as a 10-minute argument. We'll be somewhat liberal with you. Okay. We're not asking you to go 15. But... All right. Thank you.
May it please the Court, my name is Bill McCabe. I represent the claimant Carlos Silva. In this case, the judge of compensation claims found the claimant's September 25, 2006 accident was not compensable because the judge found the claimant was not fulfilling the duties of employment, nor was he engaged in something incidental to employment at the time the accident happened. The judge also made a finding that the claimant wasn't on the employer's premises when the accident happened. Now, we submit the judge has erred for two reasons. The first reason is we contend that the claimant's accident is compensable based on one of the exceptions, or actually it's really an expansion of the premises rule. The premises rule provides that an injury is deemed to have occurred in the course and scope of employment if it is sustained by a worker on the employer's premises while preparing to begin a day's work or while doing other acts which are preparatory or incidental to the performance of his or her duties and which are reasonably necessary for such purpose. Of course, the contrary to that is an accident which does not occur on the premises is generally not compensable. Now, this rule, the premises rule, is subject to several extensions, which really, to me, are expansions of the premises rule, underlying which is the principle that course of employment should extend to any injury which occurred at a point where the employee was within the range of dangers associated with the employment. Now, the doctor's case, Doctors Business Services Inc. v. Clark case, sets forth what these exceptions or expansions, as I look at them, are. One is special hazards on normal route, which doesn't apply here. Two, travel between two parts of the employer's premises, which is our second argument. And the third one is an area where the injury occurred actually used by the employer for his purposes. This court in Security Bureau versus Alvarez said that in order for that third exception to apply, the employer's use of the property must be for purposes other than those shared by the general public. We submit that's exactly what occurred in this case. The parking lot, the employer's premises, is in a strip mall with about 4 or 5 other businesses. They do not own the parking lot. However, the evidence in this case establishes that the claimant and Mr. Martinez, who the claimant would ride with every day, go to the employer's premises, get the trip tickets of the employees that are going to go to this Simons company, which is where they're all assigned to work, and then they wait in the parking lot for the other employees that they're going to take to the Simons premises to arrive and then take them.
Was it an established fact that only your client and Martinez were allowed to get the trip tickets?
Yes, they're the two that would go get the trip tickets.
Counsel, is there any evidence in this record that the employer controlled or exercised any control over the parking lot?
Well, they didn't exercise control over the parking lot, no. But the parking lot was used for their purposes in a manner that was not used by the general public. And that purpose was, that is the meeting area where employees who are going to get a ride, because some of these employees don't have transportation to the Simons company, or for that matter, for some of the other places, this is where they'd all meet.
So if you were an employee who was working at Simons, did you have to go by the staffing office and get a ticket before you went out to Simons, or could you just go straight there and work?
You know, in their answer brief, they stated, for example, the claimant could go directly to Simons. And I read the record, and unless I missed it, I didn't see that anywhere. The evidence in this case is that these employees go and they check in at the staff leasing office in Pompano Beach. And then they go from there to Simons. And the evidence in this particular case is, for some reason, the Simons employees like to be paid daily. So they come back with a trip ticket to the office and they get paid. So my understanding of the record is they all go and they check in at the staff leasing office. Now, all of them would be listed on one trip ticket that either Mr. Martinez or the claimant would take. And then they would take that out to Simons. Simons would check it at the end of the day to confirm the hours. They bring it back and get paid.
Counsel can clear me up, but my assumption on these staff leasing cases, and as you know, we're getting an awful lot of them now. I haven't noted I've seen one that dealt with going and coming. But my assumption is that the ticket, whatever they're going to call it, has to somehow be taken to the contractee or the contractor, because they're the ones that actually fill it out and return it to staff leasing.
Right. And that's exactly what happens in this case. Either Mr. Martinez or the claimant would take the ticket to the Simons. The company trusted them to do it because they'd been there for...
But it wasn't the claimant's turn to be the courier of the staffing ticket to stay.
Well, these two, Mr. Martinez and the claimant, would ride in their car together from near where they live, from where they lived.
Mm-hmm.
And generally the person who was driving that day they would give that person the ticket, but it would be given to one of those two people. So our contention is, number one, that the parking lot where this accident occurred was the employer's premises based on that third exception, because that's where everybody met to get their ride to Simons, those who needed a ride. Now, the fact that it happened at the lunch wagon doesn't make a bit of...
But only one of them had to go into the staffing office to get the ticket. Not every person who was going to work at Simons that day had to go in the office and engage in some kind of paperwork or get a piece of paper. The rest of them would just wait in the parking lot, correct?
Well, you know, to be honest, I'm not 100% clear on that, but it seemed to me that all the workers were supposed to check in at the staff leasing office for the day, so staff leasing knew who was going out there. But I'm not 100%, I couldn't really tell exactly from the record. But the record is crystal clear that Mr. Martinez and the claimant, one or the other, would definitely check in and get the trip ticket. And the fact that, as I say, that it happened at the lunch wagon as opposed to anywhere else, I think doesn't matter because of the personal comfort doctrine. I mean, there's no problem with somebody getting a cup of coffee when they're at work. That doesn't take them out of the course and scope of employment.
Did the judge address that deviation issue in this case?
He didn't call it a deviation issue, but he says he wasn't on the employer's premises. He was at the lunch wagon. Now, the second grounds that we have...
Let's change the hypothetical again. Let's say Mr. Silva and Mr. Martinez were going to the staffing office to get the ticket. And rather than go in, apparently Mr. Martinez had gone in and gotten the ticket before they went in the premises, or what everybody agrees is the premises, the office. They stopped to get coffee in the parking lot. Would that be course and scope?
Well, arguably they hadn't checked in for work yet.
Okay.
But in this case, we don't need to worry about that because this incident happened after they went in and got the trip ticket.
Mm-hmm.
The second...
Well, then how did they know who was going to show up later, these other employees they were waiting for? If the ticket was produced, you know, you said earlier that the employees had to check in so they would know who was going to be on the ticket. They don't know that everybody's going to show up every day.
I thought about that, and I don't have an answer for
you.
Counsel, regarding the second exception again, if we were inclined to agree with your argument, other than the parking lot is a place where the employees have a habit of meeting, is there any other evidence or factors we can hang our hat on in terms of agreeing with you on the second exception?
The second exception meaning the travel between two portions of the employer's premises? My argument on that is, now, first of all, for that argument, you don't even have to decide that the parking lot is the employer's premises, because the office is clearly the employer's premises, and that's where they went to first. So they're transporting it, at the very least, from the office to Simons, which is two employer premises. Now, the fact that the judge rejected that argument because he said, well, they're not in transit. He was getting a cup of coffee. My response to that is, I've cited two cases, the Schoenfelder versus Wynn, 704 Southern 2nd, 136. That's where the attorney was studying for a deposition in his apartment and then was going out to the parking lot to get in his car to go to the doctor's office for the deposition. It's really a travel between two premises case, and he was hitting the parking lot before he even got in the car. I would submit that them sitting in the car waiting in the parking lot before they drove to Simons is really incidental to the transportation to Simons, because they had to sit and wait there until all the other employees that they were going to take showed up. So they were kind of stuck there before they could actually drive to the Simons premises. But their waiting there was incidental to the transportation.
The premises rule really arises because you're concerned about hazards that are not attendant to the employer's place of business, giving rise to a workers' comp claim. But in reality, a lot of workers' comp claims take place off the premises, and the inquiry there is course and scope of employment. And it seems to me like that has some relevance in this case, whether this gentleman is in the course and scope of his employment with the employer, irrespective of where he is. And I say that, and I'll telegraph this to the other side, because if they had loaded up and they were going to the job site with the understanding they're going to be paid $3 a head to take people to the job site, I don't know that there'd be a premises argument being raised here. Might be.
Well, the reason, the reason that it's, if you're on the employer's premises, even if it's before work or after work, but you're doing something incidental to the employment and you get hurt, then it's compensable. So the question here under our first argument is the parking lot the employer's premises?
Which I don't think, I agree with that. I understand what our cases say, but you can't completely leave out the concept of course and scope of employment. You get there 2 hours early, for instance, because you want to see the space shuttle take off from the parking lot. It's not going to be covered, I don't think.
Well, no, but the question is whether it's reasonably incident to the employment. Getting there 2 hours isn't, but getting there at 6 or 10 after 6 when you've got to leave at about 6:30, and if you're late, you might not be able to work that day. There is one case that I cited in the brief where the lady got there 20 to 25 minutes early, and the court said that's reasonable in anticipation of your employment.
They need, and we've used up your time, but we'll give you a minute or so for rebuttal, but they needed to be at Simons at 7, is that the?
They had to be there at no later than 7, and if they were late, they ran the risk of being stricken from the ticket and not being able to work that day. Thank you.
Thank you.
All over myself. Please the court. Peter Egan on behalf of the Appellee General Labor and AIG Claim Services. I'm with the law firm of Kelly Cronenberg, Gilmartin, Fictel, and Wander out of the Panama City office. Original counsel of record, I believe, reflected in the court's file is Kimberly Fernandez. I'm standing in for her today because she is having a baby on Friday. To address a few of the issues that were brought up by the panel, Judge Lewis, you asked the question as to whether there was any record evidence as to whether the parking lot was controlled by the employer. Judge Hogan, in her order, this is reflected in Volume 2, pages 295 to 296, found in the underlying case that there was no competent substantial evidence presented to support the contention that the claimant was on the employer's premises. He was at the lunch truck. General Labor does not own the building or the parking lot where the...
In all fairness, though,
yes,
is your opponent arguing to the contrary in this case? Is he arguing that the parking lot was controlled by the employer?
No, sir, he's not, but I just wanted to address...
That's why I tried to focus on course and scope of employment. I realize it's not phrased that way, but the going and coming rule really is a course and scope of employment concept.
Yes, sir.
And I want to ask you 3 hypotheticals here.
Yes, sir.
Would this have been compensable if Silva and Martinez had walked up to pick up the ticket? Let's make it a further hypothetical. Let's say they've got to traverse some common property owned by this strip mall, and then they get to the door of your client, General Labor.
Yes, sir.
Pick up the ticket at the door, turn around, walk 3 feet away, they're back on the common property of the strip mall, and they have an accident at that point. Would that be compensable?
Your Honor, the case law that's addressed those issues is a couple of cases. First, Fernandez versus Consolidated Box, involved in assault on an employee who had left the employment property and was changing a tire, I believe, on a roadway. The court, in examining that case, made the determination that Mr. Fernandez's claim was, in fact, compensable because the roadway, even though it was public property and deeded to the city of Tampa, was used by no other persons, not the public. The only people that used it were the employees, and it was used for the benefit of the business as an ingress and egress.
Well, that's really not the direction I'm going in, and I apologize for not being clear. But I think the record establishes that somebody has to pick up these tickets for these folks to get paid daily.
Yes, sir.
So my question is, if they're essentially in the act, removed by 30 seconds of picking up these tickets, they're not out on the highway or in the driveway or in the parking lot, is it compensable?
I believe it comes down to the question that you asked a few minutes ago, Your Honor, is whether or not the claimant at that time, in this case Mr. Silva, was within the course and scope of employment at that time.
Well, that's what I'm asking you. Was he?
Based upon the arrangement and based upon the information in the record, the person who was driving.
I'm asking you about my hypothetical.
Yes, sir.
Which is taking you back a few minutes. There's no lunch wagon or anything such as that. He's just picked the ticket up, turns around, and has an accident. Is that compensable?
I believe it would be, Your Honor.
What if he picked up the tickets, he and Martinez? Let's just assume for the purposes of this question they're acting as a pair. I think the evidence was they sort of went to the door together.
Yes, sir.
And go back, and nothing happens at the lunch wagon, but then the riders arrive, and while they're actually loading up the car, somebody gets shot. Is that compensable?
I believe that the only person that would have a compensable injury at that point in time would be the person who was driving, who was in this case Mr. Martinez, who on that day undertook the responsibilities of driving and was to be paid for that. It would be the employer carrier's position at this point that Mr. Silva or any other passenger more than likely would not have suffered a compensable.
Well, did the JCC? I don't think the JCC really went off in that direction. Did she though, about whether it was Martinez or Silva, or did she?
I do not believe so, Your Honor.
Because Silva said I drive 90% of the time or something.
Yes, sir.
They always came together. I
Yes,
believe.
sir.
So, if you can, let me, and you gave me a fair answer, but let me focus you in a little bit more. Let's leave aside the Silva versus Martinez thing. That may end up being determinative, or may not. My question is, they're loading riders to go off to Simon's. Two of the guys are in the car, one of them's getting in, and Mr. Silva gets shot. Compensable or not?
I do not believe so, sir, because I don't feel at that point in time that he's within the course and scope of employment. His place of employment is the Simon's Company, which is 3 to 5 miles away from the General Labor office building, strip mall where this accident occurred.
Now, Counsel, digressing back to my question.
Yes, sir.
In reference to the exceptions, the claimant contends that the second section of exception applies to the facts of this case. It's traveling between two parts of the employer's premises. Is that correct?
Yes, sir. That is what the claimant consents.
In reference to that exception, would it make a difference if the employer owned or controlled the parking lot?
It would, Your Honor, because one of the issues is when you're interpreting that line of cases is, are they traveling from the employer's premises? Are they traveling between two jobs? One of the cases.
Now, would it make a difference if the claimant had already got his coffee and instead of heading to the van, or whoever, was walking into the offices of the employer at the time he was shot? Would it make a difference then?
I'm not sure I understand you, Your Honor. Are you saying that the claimant were to go to the lunch truck first and then be shot in the course of walking into the business?
The employer's office.
I don't believe so under this scenario because, again, the parking lot's not controlled and the sidewalk isn't controlled by the employer. It's not owned by the employer. And technically at that point, the difference, to go back to Judge Kahn's point and to address yours at the same time, is where the claimant reports to work. Mr. Martinez arguably would have been on the clock because he was driving the employees that day to the job site.
Don't they pool their $3 a rider somehow, though? Don't they share that money?
No, sir. It goes to the individual person who was driving that day. And
Are the other employees, the one who's not driving, are the other employees, are they required to come in and check into the office? Because it seems to me it's going to weigh heavily. You know, I know they weren't on the clock till they got to Simons, so they weren't technically at work.
Yes, sir.
But if they are required to go someplace and pick up a piece of paper or go check in so their name can be on the list, if the employer requires them to go someplace before they're actually at work, you know, the traveling between places of employment really comes into play. Were all the employees required to come there at some time in order to get on the ticket?
the record is silent on that, Your Honor. I, like Mr. McCabe, cannot address that issue because it wasn't addressed below. I would say that in this case, where Mr. Silva rode from his home with Mr. Martinez to General Labor, Mr. Silva was a voluntary passenger. He had no obligation to be there. He had obviously, I'm sorry, not obviously, but per the record, has his own transportation and could have just as well transported himself to Simon's property, assuming, and it's a big assumption, I'll give you that he's not required to go and specifically check in.
So you're essentially arguing, it seems to me, that you can win this case even if we disagree with the JCC by simply saying, even if all these arguments Mr. McKay is making is correct, Silva is out because it wasn't his day. Is that what you're arguing?
Not to
I don't mean to judge your
No,
argument.
and I understand that, Your Honor.
If that's your argument, it may well be a good one, and that's why I want to see if that's what you're arguing.
I think what the case boils down to, and again, going back to what you brought up before, course and scope. Was Mr. Silva within the course and scope? Forgetting all other exceptions, but just focusing on that argument. Was Mr. Silva in the course and scope of employment at the time of this shooting? Again, if Mr. Silva had driven that day and he was the one responsible for taking the employees to the job site, arguably, he would have been within the course and
That's
scope.
the thrust of my question. That's it.
But since Mr. Silva was not driving that day, and the record's clear on that, the employer carrier's contention is he was not to be within the course and scope of employment until he arrived at Simon's.
Let me go the next step then. You could concede almost everything that the appellant raises in this case about the premises rule and all of that stuff and say, hey, Silva was not in the course and scope of his employment. He wasn't the guy that drove that day. He may have driven 90% of the time, but not on this day.
You could concede it, Judge, but I don't know
I'm not
that
asking
I
you to
don't know
concede.
that I
I'm
want
not
to.
asking you to concede anything. I'm trying to hone down
I understand.
the argument here.
And yes, I believe that the argument would carry that the exception to the premises rule, as laid out by Mr. McCabe, okay, as well as the other arguments being personal comfort doctrine, I'm sure the Court, is familiar with those line of cases. It all boils down to as to what was the employment status at the time of the injury. Was the claimant within the course and scope of employment at the time? The argument of the employer carrier at this point in time that not only was he not on employer premises as found by the judge, which would accept several of the other arguments below, he was not within the course and scope because he had not arrived at his place of work, the Simons Company, as of that day. He was not obligated to drive, and because he was not the driver that day, although Mr. Martinez may have been within the course and scope.
Okay, so if Martinez had been sick that day and Silva had to go by himself and pick up the ticket and drive, I'm not asking you to concede away your case. But if that were the case, then we would really have to focus on these expansions of the premises rule.
I believe so, Your Honor.
Because course and scope may be a little bit easier then for the
Yes, sir.
appellant.
But that's not the case in
facts.
this case, is that correct, counsel?
I'm sorry.
But that is not the case in this case, is it?
That,
The hypothetical Judge Kahn gave you just then.
That's what it's called.
no, it's not the case here, Your Honor. Thank you.
Thanks.
I do have about a minute or two of rebuttal if I've got the time.
We will give you a couple of minutes, because I am interested in this point that he raised, which seems narrower than where the JCC went, but I'm interested in his contention that Silva is not in the course and scope of his employment under any view of these factors.
All right, well, I'll respond to that. First, I wanted to, on whether all the employees have to check in to get their ticket. It seems on page 109 and 111 of the record, which is the testimony of Mr. De La Pez, who is the general manager there, that they do. Because they're asked on what's the normal protocol, and it says the employee would come in the morning, sign in, we give him a ticket, provide him a ticket. And then on page 111 also, he explains it a little bit. So it seems like they do check in. Now, as far as the fact that the claimant wasn't driving on that day, for the second argument, it makes absolutely no difference whatsoever. If you are traveling between two employers' premises, it doesn't matter if you're driving or not. And I think a case that supports that is Evans versus Handyman, 710 Southern 2nd 132. That's where he was traveling from an employer's premises to another place to get his check. But it doesn't matter if you're driving or not. If you're between two premises and you get injured.
Well, in Evans, though, wasn't the claimant indisputably before the accident on the clock?
Yes, yes.
So you still, seems to me like you still got to pay a little bit of attention to that.
All right, well, I'm addressing whether he was driving or not, and for the between the premises, it makes no difference. It also makes no difference for that second argument whether the parking lot's the premises, because the office where they had already checked into clearly is. Okay.
That even applies if he had no reason to be there other than convenience, riding with a friend?
Well, there's no evidence that he ever drove directly to Simon's by himself without checking in. There's no evidence to that at all.
There's also no evidence on the other side that this was some sort of a joint venture that Silva and I'm sorry, I forgot the friend's name, the other fellow, Martinez, had set up. It was just almost happenstance.
Well, they were a team, and they've been doing it for 2.5 years.
Well, I asked the question about it. I said, don't they pool their $3 a rider? And he said, no, whoever drives takes the money.
I would agree with that, but they traveled together for 2.5 years, and our client drove 90% of the time. But my second argument is, even if he didn't drive, the first exception to the premises rule would still apply because, as the evidence appears to show, they all went there that morning, every day, every Simon's employee before they went to Simon's, and he was waiting in the parking lot for his ride to Simon's if he wasn't driving. I would say every employee that checked in to that office and got their ticket and was waiting in the parking lot for their ride to Simon's is in the course and scope of their employment, because they were doing an act, incident, or necessary for their employment, and that was to get from the office where they checked in to the place where they work. And they had to wait there to get their ride.
Is there any evidence, though, and I realize, we get into issues on appeal that are just all these intellectual out there hypotheticals, and the case is tried at a much more pragmatic level, let's say. But is there any evidence that labor staffing here could not have fulfilled their purpose of providing these pool laborers but for the transportation of these guys from the office to the job site?
Well, this is the only, now some of them, there was like 15 that worked at Simon's.
Right.
Many could get there by themselves, but some could not. Those who could not, and to show that the company liked it and it helped them, they're the ones that paid the extra $3. I took $3 from the employees who got the rides check and added it to the check of the person who did the ride.
So there is some evidence in response to what I just asked, that there was something of a benefit to the employer here to provide the transportation.
Absolutely. Thank you very much.
That concludes our docket, and this panel will be in recess. Thank you, gentlemen. Have a safe trip home.
Thank you.